if I make a will and I bequeath my premises to in my will.
Can you identify yourself? So
my name is Lesseps Fonseca. I'm an architect retired. I have made a will, and in it I have bequeathed my flat to somebody. Now after that I bought another flat, and in between I sold the first flat. So do I have to attach a codicil to tell of the old flat that was sold?
first and foremost, is the will registered?
No, it's not registered.
It's not registered. Why don't you just make a new will?
But is it necessary? I mean,
ideally you should make a new will, because the complication of identifying where that flat was sold, what was the taxation on it, how you bought the money, whether you have just the flat or you have some other legal heirs, is it a heredited property, it's best to make a will and put it all on paper again. No?
So that clears the situation. It has to be brought on record.
Yeah, you can make a fresh will. The earlier will gets cancelled automatically.
Yes.
And the new will comes into effect.
Thank you.
This is Ramesh Cheda. Okay, I have a question. Like, suppose if I don't want to bequeath my property, my house. I just want to give my possession right to my wife, suppose. And after the death of my wife, it should go for some charity. Can I do that?
But possession is, she's already in possession. Your wife is, I presume, staying with you.
I just want to allow her to enjoy the property.
But after your death,
after my death, definitely.
After your death, who is the owner of the property? After your death, you don't be the owner of the property.
No,
somebody has to be the owner of the property.
So I need to create a trust, and then
either you can create a trust or you create a will, which you ideally should give the property to your wife, and then after her it can go to whatever charity you want, because that's your will. She can't take the property. If that's your will and that's what your will says, then she can stay in property for life because she has been your wife. And then after that, whatever is your will, the property will follow.
So then I don't have to transfer the property to my wife.
But by the will, it will automatically get transferred, because the society is not going to recognize a no owner. No, if it's in a housing society, society needs to have some member there. But yes, if your will says that she can stay in it during a lifetime, and after her it should go to charity, that's what will happen.
Can he compel it once she is the owner? Can he compel the property to go to charity, because she can change her mind, right?
No, because that's not self-acquired property. That is an inherited property, and if the will says that it must go to charity, then the will should provide how the executors would then take possession of it after her and dispose it of.
Thank you.
Sir, I'm Surendra Shah. If a person died with the registered will and give his flat to one son, then it is necessary to get the NOC from the other legal heirs to transfer the flat to the society. He has made a will, it's a registered will. And
have you also nominated in the society?
Yes, the nomination is made.
Is the property in Bombay?
Yes, property in Bombay.
But you'll anyway need a probate for that.
It is necessary probate?
Yes. If the immovable property is situated in Bombay or within jurisdiction of the 3 presidency towns, you need a probate anyway.
Then only the society will transfer?
What the society will do is, as a nominee, they will transfer the flat to your son. But that is not ownership.
It's ownership flat.
No. The society transferring the flat to your son does not give him ownership rights. He will still need a probate if he wants to sell it to somebody else.
But registered will is there. It will mention is there. It is to be transferred to this.
The registered will help him getting the probate much more easier.
Acha. And another thing, I have 2 sons. I am having a flat, 2 BHK flat, and I have already purchased 1 flat for my elder son. And I have given him, it is 1 BHK flat. Now, in my registered will, I have mentioned that my flat, 2 BHK flat, will go to my younger son. Can my elder son object or give some trouble to this for transferring the flat?
This property that you have willed to your children is just self-acquired property?
No, I have received from my father by way of will.
But therefore, then
it is self-occupied. Today is self-occupied.
No, forget it, self-occupied. If you have acquired the property by succession from your father, then your children will also have a right to succession in that particular under particular law. So you need to come with a specific understanding. This is a specific question. Your whole will and your whole succession will have to be looked at, and then I can answer you. I can't really answer it like that. It needs a little bit understanding to to exactly know how you got the money for that flat, how it was acquired, and whether your children also have a right to succession in that property. Though you may have given it amicably today, after you, if they decide to fight, then that succession will apply under the Hindu Succession Act.
Sir, we take these questions one-to-one, or you can write to our office and we can answer.
We'll answer it because it needs a little more study. I can't, unless I understand the entire subject, we can't answer.
Hello, my name is Keita Tide. I have two questions. I have one question. You mentioned a word as trustee as well as another word as guardian. What's the difference between them?
Testamentary guardian and a trustee?
Yes, what's the
See,
difference?
a trustee is appointed under a trust deed.
Okay.
A guardian can be appointed by either the court or by you. So you can decide to appoint, say, if you have a child and you want a guardian to be appointed for the child in the event that something happens to you, you may name that guardian. The guardian becomes the testamentary guardian under the will.
Okay, my question is, since it is not mandatory to register a will, can somebody forge a signature and make a will?
You need 3 forgeries. 2 witnesses also need to forge it, no?
The one who forges it can also get 2 witnesses also.
Yeah, but you need 3 forgers. You need a group of guys doing the crime together.
Okay, my name is Durga Prasad. I just want to ask whether it is necessary to specifically identify the properties in the will, or it can be made a general will. All the movable and immovable properties standing to my name will be, the beneficiary will be such and such person.
It's best to have it very, very categorically. You must put everything that is there, account numbers of bank, the property details, as clear as can be in your will.
But that can be only on a particular date, and the will come into a later date when some of the identified properties will change and new ones will also be there.
You have a residual clause in every will. It's always provided in the will that subsequent to the will, if something is acquired, how to deal with that. Okay, without naming that, but whatever is on that particular day in your possession must be very clearly mentioned. It's better for everybody because then there is no ambiguity on how interpreting the will.
Or a line can be added ki even if something is, all the major ones will be mentioned, and if anything might no, he says it is only for subsequent ones, even in the current.
No, that's the residuary clause covers subsequent to that. But in the will that you make, on the day you make it, it is very important that you clarify in detail all the movable properties that you have and how you want it to be transferred to your heirs.
Thank you.
Can the will be revoked after registration?
Yes, of course.
So again, you have to go and register.
You need to register. You can revoke the will, make a new will, and that becomes the final will on that particular day.
If a will is to be registered, then what are the charges? How the fee is charged for registration?
It's not. It's a slab. It's different slabs for registration. But you'll have to look at the stamp duty, and I can't answer the question. There are charges, registration charges, but not something.
No, but there are the charges depending on the value of the property.
No. It's a nominal slab for us. You're not transferring the property.
Excuse me, sir. Is Ashok Raghavan. I just will.
Sorry, come again.
Just want to ask a question regarding inherited property.
Yes.
In case the property has been transferred into somebody's name by obtaining the NOC of the other people who were supposed to be successors under the Indian Succession Act, it has come into the possession of one person and then it is getting transferred to the subsequent, on the death of that person. Does the niece or nephews of that person also have a right on that property?
Well, are you covered under the
Hindu succession?
Hindu succession.
Yes.
When this first transfer happened, did you take any corrective measure? Did you go to court?
No. By getting NOCs from all the other people who are heirs, property was transferred to only one person.
There was no will in the first place.
There was a will in the first place was only for the this relates to my wife's mother. Now wife's mother had the property transferred to her name, and she has son, daughter and husband. So automatically I think that property is going to get transferred to all three.
Automatically, if it is by will, then the will govern.
Yeah, there was no will. There was no will.
Exactly. You need to give me the entire details on a one-to-one. I'll look at it and I'll answer it. I can't really answer it.
Thank you.
Taking off from the once the will is registered, all subsequent wills necessarily have to be registered.
Not necessarily.
And
no.
Not that the original will prevails over the subsequent.
No, the subsequent, the last will prevail.
No, not the original.
No.
Registered will. Because this is a very common question.
No. If it has been revoked, what happens is that the subsequent will, you first start by saying I revoke all my earlier wills if I have made, and this is my final will. So the language itself revokes all your earlier wills.
So the subsequent wills will not be registered.
Not, it's up to you. You want to register it, you don't want to register it. So that's a debate in public, whether you really want to register a will. Because if you register a will, you're putting it into a box. If you're sure of what you want, and you're not going to change your mind, then go ahead and register it.
Not very difficult either.
No, it's not difficult. It's not difficult.
Excuse me? Satish Sutaria, my name. See, I have 2 flats and then several other like mutual fund units, FDs, shares, etc. Now, I have 2 questions. FDs, shares and mutual fund units will keep changing all the time, in the coming period. So if I make a will today, me and my wife together, that in the absence of any one of us, the entire property till the life of the another surviving spouse goes to her or him, and after that flat A goes to son, flat B goes to daughter, and the rest should be divided 50-50. Can we just make a small will like this, 1 paragraph will, that flat A goes to son, flat B goes to daughter?
You can do what you want.
And rest 50-50 without specifying.
You can do what you want. It's your will.
But, I
Is it?
just want to make a supplement point to that. I remember wrote a will of 150 words and heirs spent 2 years and thousands of dollars for what he was saying. So
that's what I said in the other question, that you need to be very clear about what you want.
So if there are 2 flats, as I just want to explain the process of making nominations effectively, both for movable and immovable properties that we
See, but again, dealing with nominations and wills, let me clarify to you. See, nomination is not succession. Nomination does not give you right to the property. Nomination is merely you're holding the property in trust. You still has to establish that there is a will and there is an owner. I mean, it has to be transferred to you.
But I'm little not clear on the potential complication for a will like this, where I say, because rest of it is a movable property like shares, mutual funds and FDs. And it is clearly stated flat A goes to son, flat B goes to daughter, and the rest 50-50. So I'm trying to figure out, is there a potential, or do we need to, because you see FDs, mutual fund unit, stocks, everything will keep changing all the time.
You see, as I said earlier, you can make a simple will and
so
be done
is there
with
a
it.
potential complication? That's what
Of course there will be. There will be. There will be, because to decipher who gets what is going to be a problem. You have to very clearly specify how your distribution of your flat will be. In the society register, also you should have your nominations in place.
Flats is simpler. I'm saying the rest 50-50, suppose if I say.
You're talking about the movable property.
Movable, meaning shares.
Let me ask you, let me give you an example. The shares of Reliance to your 2 children. Prime Minister, maybe tomorrow Reliance will go down, or
Reliance is also Sora, by the way.
or some other company. The point is that unless you decide, if you say 50-50, if your children don't fight with each other, then it's wonderful, they can do the math and one fine day decide to split it. But if you decide to fight, then, and you don't want them to, then you'll probably have to say that these shares go to so-and-so, or you'll have to split them up, and you'll have to make the nomination accordingly, which I think today with this NSDL and whatever it means, even having separate depository accounts and keeping them separately, because one account is one person, another account is another, and you can't have the same. It's become very complicated because NSDL has made it in the electronic process much more complicated. So, I think we'll stop with your questions. Resource forward from there.
Are the assets of a will in the hands of a beneficiary taxable by law?
That's as for the tax. Taxable in what way? As having received it? No, there's no tax on receiving the property. There's no tax on receiving the property. No.
Hi, I'm Sachin Khanna. I have a couple of questions. Sure. The first one, if I'm born a Hindu and I would like my will to be administered under a different act of a different religion, possible?
Under Indian Succession Act.
Yeah.
There are only Hindu Succession Act and the Indian Succession Act. There is no other.
No, in your presentation it was mentioned that
it's Muslim personal law. There is no law. There is no act.
Yeah, correct. So let's assume that I'm born a Hindu and I've taken over
Islam.
Yes. I haven't changed my name, but I've lived my life like a Muslim.
Yeah.
Now, when I made a will, I've gone and made a will saying that because I've lived.
Ideally, would be to make it under the Indian Succession Act.
Okay.
Because that's the Indian Succession Act, specially designed for this kind of cases where people change religion,
Fine. Just one more small question: is it possible that I can have a no contest clause if I?
That is impossible. How can you have a no contest? That's your will. I mean, that is how it has to be.
Any kind.
You can put it in, but that doesn't bar somebody from contesting that will. You can put it in, but I mean, if the children are happy with it, fine. But if they want to contest it, you can't stop it.
Well, if I've done any 50% equality, and I don't want them to contest, is it possible to put it?
You can put it in.
Sachin, I think it has happened, if I'm not mistaken, someone like Frank Sinatra or somebody made a bill which said that if anybody contests it, they automatically get disinherited. And apparently even then it went to court because the person who was supposed to execute it was dragging her feet on it because she didn't want to share the property.
Absolutely.
But the clause is possible, but it happens more in America. And I would suggest again that in America, faster.
Here it will take a long time.
This is for your children. Don't tell them to do something that they'll have to go to court about.
You can put it. Of course you can put it. You can put
Internationally, it is known. Frank Sinatra, who had done it.
Sir, I have a couple of questions. Is there a time frame for the will to be probated since death?
There is a time frame, 90 days. You have
90
to
days.
90 days.
And you also mentioned that the trust protects your assets from probate was on that. How does it
trust,
protect?
what happens? You set up the trust before you die. Your will sets up the trust. Okay? You don't need to go for probate because the executors would be then taking care of how to enforce your will.
So then the probate stage is not required.
Probate is required if the property is situated in Bombay. The executors will go and take the probate.
So even if there is a trust in Bombay, still a probate would be required.
If it relates to an immovable property in Bombay, yes, a probate will be required. If it relates to immovable assets outside Bombay, no probate will be required.
Sir, one more question. Do you need to leave a copy of the will with the executor, or does the executor need to be...
Let me put one more thing. You need a probate if it is contested. Okay? If it is not contested, the will, then you can just forget the probate. If you are just one person receiving the property, nobody contesting it, you don't need a probate. Many companies insist that they need a probate or a succession certificate. But if your society is accepting your will and NOC and trusting property, the probate is not.
Follow up on that case. Do you suggest that we might as well give reasons in the will for why these are influenced?
If you're asking me my advice on a will like this, without going into the philosophy of it, I think it is very prudent that when we have a family, when you make a will, you call your entire family, explain to them your will beforehand, and everybody knows what your will is. Some people keep it a secret for various reasons. But if your family knows what your will is, then usually there is no... It's your family. I mean, it's your children. You have brought them up. It's your legacy.
Another question is, if somebody makes you an executor without telling you, and you suddenly land yourself with the will, you are an executor, is there any way you can get out?
You can excuse yourself.
How?
Well, then
how does the moral and the legal
it's difficult. It's difficult. Many cases the executors say that no, not me. So the family then has to decide who will execute the will.
Again, as an NGO, I must mention that there are lots of cases where the executors say nothing doing because the legal process is very difficult, and especially when they know children are going to fight and brothers are going to fight, nobody wants to be the executor. So especially in situations like that, you have to talk to a person, and I think, as Sachin would advise, that you also, in those cases, make a provision. Because a lot of wills don't make a provision for the payment to the executor. So if the executor has to keep running to court, has to get some advice, get a chartered accountant, if you have not provided in your will for him to be paid, why would anyone want that dirty job?
No, but even otherwise, you're not supposed to benefit.
Who, the executor? He may not personally benefit, but he needs to spend money to execute a will. That
his costs at least you have to have something.
Yes, he has to.
Come back.
Hello. Yeah, my name is Mala. I was wondering what happens if you are an OCI. Can you make
sorry,
the will?
I don't see you. Oh, sorry.
Yeah. If you are an OCI, you don't have an Indian passport. Make the will here, and that will work.
Yes, of course, you can make a will anywhere. Doesn't matter whether you are an Indian citizen. If you have assets in India and you want them to be the succession under Indian law, you can make a will in India. The will will also apply in the US, wherever you are.
The same will apply in the US too.
Yes. It's your will. Your succession will depend upon your taxation on your US assets, or your overseas assets will be dependent on whether they have succession taxes there. But the Indian law will govern your Indian assets.
I announce here that you have agreed to do a round table.
Yes,
I think since there are lots of questions which are specific to people's cases, earlier I asked Sachin if he will do a round table, but we earlier announced that our round tables will be free, but we're now going to charge a 500. But if you want to come to cases, then he is on 16th afternoon. So if there are people who want it, then after this, tell us, and then we will request the management take an appointment.
But before that, if you are coming, I need a brief of what your case is to advise you guys.
My name is Ravindra Shetty. If an executor refuses to carry out that job, he said that I just don't want to execute this will because it will create bad will or whatever reason, then what people are supposed to do?
The beneficiaries can then go to court.
Okay.
They can also move the court for a probate. And the court may then decide to appoint an executor or an administrator, or the court may just decide to enforce the will.
Yes. Can there be alternate executors? One,
Yes,
two,
yes.
1, 2 and 3.
Yes, of course you can. You can the survivor also. If somebody is passed away, you can have somebody else to be.
A will can be made only for self-owned properties, right? Yes. So if I have created an HUF from, what happens to the property which is acquired in HUF?
So that's the HUF property, no? The succession is by HUF.
So it
by the succession law of the Hindu Succession Act. You can determine, or you can put in the will how that HUF shall function, or how that HUF would but your HUF would be for the purposes of tax, right?
Especially the NSDL is insisting that you obtain a probate for the HUF.
That's what happens, because when you have an HUF...
No, but when you say that you can't will the property through of the HUF, because it is not actually now your property. Property belongs to HUF, but the NSDL is insisted that you obtain a probate. So what?
Because the shares have to be transferred to some name.
I'm Mr. Shah. I think a lot of queries regarding the probate which is on, and I think there's still a grey area. First of all, is probate compulsory or is it recommendatory? Secondly, in a cooperative societies, or even if it's a individual bungalow, as you rightly said, the companies or the housing society or the land authorities, they would not normally if there is no dispute among their beneficiaries, is how to go about it if there is no probate?
See, if you have a probate, It's certified with the
I
court.
think you have asked this question in a previous seminar on wills, and I think the answer is the same, that everything depends from society to society, and as he said, if there's no dispute clearly or there's only one beneficiary, and I think everybody recommends that make your will as clear as possible. One of the questions that you asked,
let me answer it in another way. What you can do is you can write to the Register of Society. There are 5 or 6 forums where you can approach and tell the Register of Society that this is the problem I'm facing, and maybe they'll give some directions, hopefully.
But I'm talking about his will. So what happens after him?
No, that's
what I'm saying. That if it's somebody and you've inherited, then there are a lot of remedies that people could suggest. But what is going to happen after you? Nobody's going to know. Yeah, that's right.
Sachin, a witness cannot be witness cannot be a signatory, right? I mean, cannot be a beneficiary.
A witness cannot be a beneficiary.
Correct. But can the executor be a beneficiary?
Yes.
There is no problem with that.
No.
Okay, thank you.
I mean, your wife can be an executor.
Can you tell us something about setting up a trust?
Setting up a trust is really the simplest and the best way to do succession. Trust is registered in the Trust Act. You don't need to register a trust if you're doing distributing movable assets. If you're doing distributing immovable assets, yes, your trust needs to be registered. You can have trustees, you can have individual as trustees, or you can have a corporate as a trustee. In fact, the company that I was CEO of was called ILFS Trust Company Limited. It's a SEBI-regulated entity. So, in the event of a dispute, of course, you have SEBI to complain to. The good part of a corporate trustee is it's in perpetuity. If other trustees have died, the corporate trustee never dies. Cost is an issue because it's going to be more expensive to have a corporate trustee because obviously it's a corporate and they have their costs involved in it. But the trust is in your lifetime. You are one of the trustees. You can be one of the trustees. And you can decide how the trust functions from before you even pass away. So when you pass away, the trust continues in the way you intended it to continue.
Sachin, just to expand on that question, will you give us some idea about the cost? What kind of charges will be involved?
It really depends on the corpus of the trust and how much work is really involved in it. If it's just a simple trust, I don't think it would be much expensive, but let me not hazard a guess on this.
No, let me make it a little more specific. Today, property prices in Bombay have gone up so much that I think anybody who lives this side of town and has a 2-bedroom apartment would have a 3 to 5 crore worth of assets. So, for assets of that size, is it even worth creating a trust?
Let me put it this
and
way,
what would be the cost?
See, let me put it this way. If you're creating a trust of an immovable property that's costing about 3 or 4 crores, stamp duty is involved. Because you're transferring the asset to the trust. Do you want to do that? That's one question. You can transfer it into your trust by will. So after you die, the property goes into a trust. That's the way to do it. You avoid stamp duty there. But then how do they distribute? And what happens to that distribution is what the will and the trust needs to determine upfront.
So is it recommended and what would be the cost?
See, trust is recommended when you have really large assets. Executor is recommended at all times. The trustees can be executors. You can appoint the trustees to just be executors. That will not really cost much because they will be paid out of the proceeds of the execution. I mean, whatever cash is there, they can be paid out of that. That's the best way to really do it.
Would you have some kind of benchmark that if your property is not less than 50 crore, don't make a trust or something like that?
No, I wouldn't say that. If it's a very complicated structure, then it's better to have a trust.
And
even if it is a small amount of.
What about trusts for special children? People who have children.
Very important to have them.
Then, even for small amounts, is there a high cost involved?
Not really. I don't think so because. It's really how to negotiate with the trustees. You don't need to have a trustee, a corporate trustee. You can have individuals as trustees. You can have a lawyer or a chartered accountant or a friend as a trustee.
But there is no act, as someone asked you earlier. If the trustee then wallops some money, doesn't take care of the child, puts them in an institution.
You have the IPC.
But the child is helpless, right? You have a retarded child. What will the child?
Those are issues that I really can't answer. But yes, you can. I mean, if something like that is to happen, I mean, it's a fraud. What does one do?
can a third party then take them to court saying
Yes,
there was a...
Of course, you can take them to have a third party, or you can appoint an administrator together with the trustees, like a doctor or somebody who, or a special care institute who can, then step in and say, okay, the trustees are not doing their job, so we need to be appointed administrators and, approach the court for that. So that's a possibility.
Does the bank here have trust departments that administer the trusts?
Yes, some banks. The Central Bank of India, in fact, has a huge department, the trustee and executive department, and many banks have trustee companies. Yeah. They have a trustee company which really is made for financial instruments like debenture trustees.
Oh, I see.
They also do trustee function for individuals, and many times now wealth managers recommend appointment of trustees. So there's huge business happening in that category. Right. So yes.
Okay, thank you.
You said all the pages of the will have to be signed by the person writing the will.
Initial.
Witnesses do not.
Yes.
Initial. But then you said witnesses need not know the content.
They don't need to know the content. No, they
have
just
only.
It's better that all the pages are initial because everybody knows that that's the full will.
Another small request: is it possible to circulate or give us a sample draft of a will?
Well, it's on the website of Moneylife. You can. There are 3 or 4 options. See, if you want to make a will, you go on the internet. You can make a will for right from 200 rupees to 8,000 rupees, 10,000 rupees. There are various tools available on the net. You can go and decide what you want. But there is no given format. Many companies have design structures, tools where you put down all your assets, and you have highlights coming in, your nominations coming in. You need to look at that. But a simple will is there on the Moneylife website.
My name is Yogesh Chauhan. My question is, what is the procedure to register the will? Where to register?
Register of documents. Register documents at there are various offices now, depending where you are located. Old Custom House, Bandra Kurla Complex,
Chembur,
everywhere. Wherever you register your conveyance is where you can register your will.
Okay. Another question is that can beneficiary, one of the major beneficiary of the will, become executor and trustee?
Yes.
Depriving the right title and claim of other lawful claimants.
No, but it's the trust that is determining your this. How can he take away something from that?
Okay, it is possible.
Yes. One, I just saw my colleague walk in, ex-colleague, Kajal. The question they had was on charges for, throw some light on that.
So when somebody is looking at creating a trust, as Sachin rightly said, a trust is a structure that one puts in place during their lifetime for things to be exactly the way he or she wants it to be post their lifetime. So if a structure is up and running, and if you think that this is not the way I thought it would happen, you can always amend it during your lifetime, which is not possible in case of a will. As far as the cost is involved and what is the cost benefit which is involved for a trust over a will, we would say somebody who's looking at assets worth around 8 to 10 crore of financial assets, or even 5 to 8 crore of financial assets, the economies would fit in. However, we do have families with lower corpuses also, especially when you have children with special needs. So when I'm talking about creating structures for children with special needs or for families who do not have immediate descendants, and the threat that they run is, what if we live too long, who will take care of us? While we have money at our disposal, but it should come to us when we really need it. So there are families who create structures for those reasons as well, where the corpuses may not be as large as 8-10 crore, but even a smaller corpus works for them. As far as trustees tugging the beneficiary or who will take care of it, there are more than enough provisions which are put in place where a guardian is appointed, a protector is appointed. Their role may not be a day-to-day activity, their role may not be a day-to-day administration, because the concern that families have is that they may not have the time and the wherewith to look after the child, and therefore they are going to professionals. But they can somewhere always overview the activities of the trustee, and whatever is documented, trustees have legal liability towards it. So if the question is to take care of the child, as trustees we would ensure that child goes to the medical treatments are available on periodic
No, the question, Kajal, was that whether if it's an individual who thugs. When the corporate takes over, of course, the corporate is, you can
as far as an individual is concerned, you always run that risk, and therefore there are times when parents don't even want to have their child depend on their siblings, because today, yes, there is a lot of love and affection towards each other, but the one who's a normal child may eventually move on in life. You don't know how their spouse would come up to be. They will have their children, they may move to another country. They don't want to penalize the child who is normal to take back seat and take care of the sibling who is a child with special need.
Can I ask, there's a specific question that's come to our legal resource center where this man says that our mother's passed away and there are two of us and I don't want a single penny. My sister is retarded and I want all of the property to go to her and I need to create a trust. We have not answered that query because we don't know how to answer it. So would you be...
So we can create a structure for them.
Right,
we can create a structure for them.
I mean, would you sort of give us some indication of what the fee would be and what...
The fees would be somewhere, fees are completely dependent upon the complexities which are involved in the structure. However, the ballpark figures would be somewhere between 4 to 5 lakhs. This is a one-time activity, this is a set-up fee, and then there is an annual fee to it. Annual fee is corpus linked. So, because somewhere when the corpuses are low, families don't want to deplete the corpus to maintain the structure altogether. And our point is that when I'm talking about creating a structure, the time involved would remain the same. I would not defer it based on the corpus.
So 4 to 5 lakhs is the cost of creating a structure.
But that is negotiable. That you can.
No, but I mean, I'm here running an NGO where people think paying 10,000 rupees for a will is
That's
expensive.
what I said, Mr. The cost is something. Cost is something which one needs to look at and determine whether it is. They want to have a corporate trustee to manage, which is more reliable than an individual. So those things somebody will have to think before.
Right now we are earning. So when we become, sort of semi...
Doctors never retire. Doctors never retire.
They never retire. So it's going on. But you can always, doctors can be invalid or semi-valid or whatever. So at that time, one can make a trust for that time or something?
Yes, one can create a structure today, sir.
Yes.
However, the payouts can happen once the income stops at a point in time. Or one of y'all is there and the other one needs certain kind of assistance from them.
The best is the most, no, the will is independent of a trust. The trust today is the most secure mechanism for succession planning or for any eventuality planning. Because, and especially having a corporate trustee, it gives you that much added benefit. It costs, of course, more, but it gives you the added benefit that yes, it's in perpetuity, it's somebody responsible, it's governed by a regulator, and you will be that trustee will ensure account transparency, clarity, honesty, will compliance with all statutes. All that is taken care of.
Integrity is something which is most important when you create a structure. That trust is very important because that's the essence of the structure.
It's in the name itself, the trust.
Excuse me? You said about trust. Does trust have any, is it any entity and...
Sorry?
Is it taxable trust?
Yes, it is taxable.
Yeah, of course,
it's a family private trust.
So is it equivalent to HUA?
Individual.
So suppose property is transferred to a trust.
The taxation is in the hands of the trustee, not in the beneficiary. That's the question you're asking?
Yeah, who pays the tax?
It depends on the structure of the trust.
It's a revocable, irrevocable trust will determine what taxation.
What kind of taxation comes in. But from the Indian perspective, there are no disadvantages of having a trust, there are no advantages of having a trust. It's a trust, trusts are tax neutral. Trusts in India are at this point in time tax neutral. There are no advantages, there are no disadvantages. So if you are holding a particular asset in your individual name and if you transfer it to the trust and whatever income is being generated out of that asset, you either trust pays the tax or you pay the tax in your individual capacity.
It's
there
not
are no
double tax.
Yeah, there is no double taxation.
See, if you're looking at trust for the purposes of taxation, it's got no benefit.
But
it's tax neutral.
Neither advantage, neither not disadvantage.
For tax purposes
at
only.
this point in time.
Yeah, but for succession, it is very advantageous.
Okay.
But didn't you say, Sachin, that if you transfer your property to a trust, there's stamp duty involved at that?
Yes, immovable
property. For the financial
Immovable property is not
assets,
required.
There's no problem.
Even the transfer out of the trust also, would it not require the charity commissioner's approval?
No, no, no.
No, there's no charity, no.
This is Indian Trust Act.
Because see, this is governed under the
Indian Trust Act. See, if you have a charitable purpose, a charitable trust, then you need to be governed by the charity commissioner.
Because once your trust is registered,
It is not charity, it is for private trust.
this is where a lot of
The normal perception that people have towards trust is that when I say trust, they deem it to be charitable. But we are not discussing charitable trust over here. We are talking about private trust, where the beneficiaries to this trust is going to be your family members. It's going to be yourself, your spouse, your children, or whoever you wish to be. It's not going to be public at large as charity. So there are no income tax, even when the assets are being transferred from your individual name to the trust or from the trust to the beneficiaries, there are no tax implications at those levels.
No tax, but stamp duty yes for immovable
For
property.
immovable property.
So would you do a trust which has only immovable property and keep the movable out?
Possible.
No, but is that an advantage? Is it what you would recommend?
No, you do the reverse.
Start with
You
financial
reverse.
assets.
You start with immovable property and then transfer the immovable property.
See, more often than not, when I'm talking about immovable properties, it's usually the house or something that you are residing in, which is of utmost emotional attachment, which you want to keep it in the family and pass it on. As far as you're alive, you're anyways living in that house and you're taking care of it, right? So to begin with, usually families start off with financial assets. Once they get that comfort, they may look at transferring the immovable property also. And as Sachin also said that when you are transferring the immovable property during your lifetime, there's a stamp duty implication. But you can always do a combination of a trust and a will, where through your will you transfer the assets to the trust,
So
and
no
then
stamp
there is no stamp duty implication. It is inheritance for the trust, and therefore, and so far in India, there are no stamp duty implications on inheritances.
Any more questions of trust? What is the exemption limit?
Trust pays taxes at the maximum marginal rate.
Whatever is the maximum. No, if your individual tax is 35%, that's the tax it pays.
There is no exemption limit.
No, there is no exemption.
No, there
Whatever
are
is the, what is the,
There are no slabs. There are
no slabs also, yeah. The maximum.
Trust pays tax at the maximum.
The will, through the will, the inheritance, the trust gets the property. Now the property needs to come back to the legal heirs.
Beneficiaries.
Correct. So again, then there'll be a stamp duty
No,
again.
then there is no stamp duty at that level. When the assets
That's
are
a
being
dissolution of trust.
Yes, it's the distribution of the asset, and so far there are no stamp duty implications or income tax implications at the time of distribution of assets from the trust in the hands of the beneficiary. So we pay stamp duty once at the time of contribution. At the time of distribution, there is no stamp duty implication.
No, but if I've done it through the will, then absolutely no stamp duty involved anywhere, correct? No. And the trust
That's
does
inheritance. That's inheritance.
Yeah, and then once it even goes.
We're talking about immovable property only.
Immovable property. Thanks.
For a trust, there is no probate which is required.
No. My question is, in case you're putting property into a trust, is there any way to control or ensure that the trustee, if he has to dispose of the property and then distribute the proceeds, that the property is being disposed of at the right value? Is there any way to control that?
Yes. There is enough control given to the family members to overview the investments of the trust, because as I said, my business is to act as trustee. We are not a wealth manager, we are not a banker. So where the investments have to happen, whether the particular asset is supposed to be sold off, bought, is all something that family members decide. So there is enough indirect control given to the family to overview on the activities of the
There's also a concept of a protectorate. You can appoint a protectorate. You can appoint a third person who's got nothing to do with this to just ensure that what is being done by trust is.
He's like a watchdog on a trustee to make sure that trustees are abiding by whatever is there in the document.
And
so
that
he's not a
protector-
settler, he's not a beneficiary, so he's a neutral entity. Again,
Okay, he
somebody
can be
who's a
anybody.
settler's confidant.
Can an NGO be a trustee?
Well, difficult. NGO be a trustee of what?
Instead of a corporate trustee.
So
Well,
a corporate entity as a trustee.
See,
can
an
I-
NGO is a. NGO is not a. No, corporate entity is a
Nor is
trustee.
any corporate entity.
No,
It is
of
a specific trustee company, right?
ITCL is a corporate.
Correct.
And the trustee is then ITCL, not an individual.
No, but ITCL is a trustee company. It's not like any other company can.
No. Why not? Why not? You can have anybody as a trustee, but an NGO can't. NGO is by definition. But it's for a specific purpose. Its objective is not to act as a trustee.
And in case the objective is modified,
you'll have
one of the
to
objectives.
see. Then you may lose your tax. Then you need your tax benefit. You may lose your charity commission restriction. So all that, if you consider you want to be a trustee, fine.
Any other questions on that? One second.
Just as all these asset management companies are registered with SEBI.
Yes, a debenture. See, ITCL is a debenture trustee company registered with SEBI.
Okay.
Okay, so they are registered with SEBI. Trusteeship of wealth management is not regulated, but a company is regulated by SEBI. So in the event that the company or the trustees do not perform their role, you have a right to approach SEBI and complain against the trustee.
Is the regulator for all these trustee companies?
SEBI is the regulator for all trustee companies, but those trustee companies are for financial assets like debentures, bonds, stuff like that.
Then who are the regulators for the?
There is no.
For the private space,
So in
it's only
case of
income tax.
grievances, where do we approach?
The court.
Grievances against the
court.
court.
Here you are creating a immovable property. How do you manage? For example, if some person is having a land or a flat, okay, now you must want to keep it vacant to be occupied only by certain people in the family. Now, when it is kept blocked or a vacant land is there will be some enforcement or there will be some enforcement in the flat. So all such security measures do you have with you, or you just ask the persons to do that?
Well, somebody else will have to be appointed and paid for. Somebody to look after the asset. If you appoint a watchman to look after the immovable property or land, that agency will have to be paid for. No, the trust assets will have to pay for that.
We are giving you to act as a trustee. That means we are giving
Not
you
me,
money.
the trustee, not me.
Whoever is, not you, you have come here to talk about the trustee. You means here I am talking about trustee.
Okay.
Okay, trust.
Okay.
Then I am giving a certain thing to trust. Then trust should take the responsibility of other things.
Yes,
also.
of course. If you have to,
We are just managing the records, that encroachment and other thing is your responsibility. If you say so, then of no use.
No, you're right. That the trustee can provide for security of the assets of the trust, and how that security is to be paid for. Where somebody is to pay for it.
There is an out-of-pocket actual expense.
Paid for, I have not said it. We are going to pay.
Yes, so it's we can manage. We can manage immovable properties. So if there is a flat which is there, you have to pay the maintenances to these societies. You have to make sure that the utility bills are provided for, so that there is electricity available, telephones available, all of it at every given point in time. So the entire property management can be done. We can make sure that there is no encroachment, nobody is opened the locks and residing in that house, or if there is a barren land, we've appointed a security guard who would make sure that the land is vacant and it is there for the beneficiaries. But whatever are these expenses have to be an out-of-pocket expense.
Then it is the trust's job to protect
It becomes the trustee's duty.
The title of the property.
Just the last question on trust. You said that we could transfer our properties to the trust to avoid getting into probates and all that stuff, correct? But if I have to transfer it through my will,
No, come again. Sorry, didn't understand that question.
if I transfer my properties to the,
It's already transferred.
correct. So then there's absolutely no issues as far as probates and all that stuff is concerned. But if I want to avoid, but at that time the will can be contested, correct? By the
Yes, of course.
And then it again goes into the.
But you are alive when the trust is set up. You are alive to look at.
Yeah, but that is only if I don't want it to be transferred through the will.
But the structure is
If I want, because if I have to pay the stamp duty, if I now transfer everything to the trust, I need to pay stamp duty
on immovable property.
On immovable property. So if I got a 10 crore property, I need to pay stamp duty on it. If I want to avoid that, best way is to allow my will to be transferred to the trust. But because you can transfer the will, there is a probability that my beneficiaries can challenge or contest the will before the trust gets the property.
Yes, it can be challenged.
So it's again that legal risk is still there.
Risk is there. If you, but you know, you're doing your will and you're doing a transfer with the beneficiaries involved in it. So the question of them tomorrow saying that no, I was a beneficiary when everything was good, but when the going is bad after you're gone, I want to contest it. That becomes difficult for them too.
Gone, I really don't know. Correct.
And the trust is dissolved.
That's right.
Excuse me. Can we make a will for a wife to use the property for a lifetime, and only after death the property is transferred to the children?
Sorry, can you repeat the question, please?
Can one make a will for the property to be used by wife during her lifetime, and only after her death it is
yes, you can do that.
Ownership is given.
Yeah, but the management committee of the society needs to know who is the owner, no?
Yeah.
So during her lifetime, she becomes the owner.
She becomes the owner.
Obviously, because the society property is owned by the society. You're only a member of the society. Somebody has to be a member, no?
So in that case, the property will be governed by her.
No. Because it is your self-acquired property, even after her death, it will be governed by your will.
Thank you.
Thank you so much.
You can do a joint will also. It really depends on the situation, how it is.
Thank you so much for answering these questions on trust. Do we have any other questions on wills?
On the question of probate, probate is applicable only in Bombay,
Calcutta,
presidency towns. If part of the property is
probate is also applicable in other towns. Okay. In these three cities, it is compulsory for immovable property, if disputed, if contested. You can also get a probate in Mufazzal towns. The provisions apply. If there is a disputed will, you can get a probate even in any other district.
Right. But my question is, if one is staying in Bombay and there is one property and there are other properties in, say, Gujarat, the value of that property is huge as compared to what is there in Bombay. So, for obtaining probate, is it going to be Bombay High Court or is it going to be Gujarat High Court, which is a jurisdiction for obtaining it?
Gujarat doesn't have a High Court. You can do it in Bombay, best, because one time you are paying stamp duty. Why do you want to do it different? 75,000 rupees is a tax. So you can do it in Bombay and then.
Wonderful. The workshop arrangement has obviously got a lot of questions answered in a much shorter time. So in 1.5 hours, we've actually exhausted the questions.
Great.
Is there anything else that you want to add that people have missed out on? Maybe some examples?
I think we've covered most of the time.
Whatever he has asked, one small question. A person is having a property in multiple states. Let us say he is having a flat in Mumbai, land in Gujarat, another land in Goa. So he has made a will here in Mumbai. So it is probated in Bombay High Court, and then that same probate can be taken to Gujarat and other.
Yes.
It's valid. Not necessarily that again you have to do that.
No. Huh? Probate is only one probate. Your will is probated. That means this is the final lender and the right will.
The jurisdiction is different.
Doesn't matter. Jurisdiction, it's got nothing to do with jurisdiction. It's the jurisdiction of your will, not the property.
Sir, if the nominee to the property have got transferred the flat in their name without obtaining other claimant's signature or NOC, and transferred the flat within 11 days in the name of nominee from the date of submission of papers by the nominee, then what is to be done?
Go to court.
But is it challengeable?
Of course. Of course it's challengeable. If somebody has done something illegal, of course you can challenge it.
It is totally illegal, no?
You can challenge it.
My question is, if you die without any dependents and you've passed away without a will, who do your assets go to? Do they go to?
It will be governed by the Succession Act.
Okay. So it could
if
go
you're a
to
Hindu Succession Act, Parsi, Muslim.
By virtue of, let's say, a Hindu Succession Act, does that go to your cousins or your other family members?
There are various classes under Hindu Succession Act. There's a Class A, Class B, Class C. It depends on where you fall. So it's a very complex. If you read the Hindu Succession Act, there are various classes of people who get what.
Right. And if you had to create a will where you have given something to your distant family relatives and you've given the bulk to philanthropy, can that be challenged at any point of time?
No. If your will, if it is your self-acquired property, you can do what you want with it.
So they cannot at any point of claim that, this is unfair to them.
I repeat that it has to be your self-acquired property. If it is ancestral property, it can be challenged.
No, self-acquired in the sense if it's passed down to me from, let's say, parents, and there are no other siblings.
No. If it is passed down from parents, then yes, it can be challenged.
But if there are no siblings, only distant relatives, they can still challenge that?
No.
You have to look at that pyramid. If there is anybody within that, they may challenge it, but not otherwise.
Okay.
It's a class, there various categories who can challenge it, how it should go.
Okay, thank you so much.
So with this, we bring the session to a close. I think if you all have any more questions, then we'll take it one-to-one. So thank you very much, Sachin.